Good morning, Mr. Schleckinger.
Good morning, Mr. Chair. I represent the appellant, the plaintiff below, the insured below, Uniscribe. Uniscribe provided litigation support services to law firms, including the Los Angeles office of Jones Day. Jones Day hired Uniscribe to image documents for a large litigation involving its client, DirecTV. When Uniscribe fell behind its schedule, an employee brought his nephew in to help out without the permission of Jones Day or Uniscribe's management. The nephew proceeded to take part of the confidential documents that belonged to DirecTV and send them to an internet website. When DirecTV ultimately learned the source of the leak, the source of the leak was the documents it had given to Jones Day, it terminated Jones Day from the case, and Jones Day was forced to write off $1.4 million in fees that it was owed. The incident was widely reported in the press and was professionally embarrassing to Jones Day.
How old was this young person?
The uncle or the nephew?
The nephew.
Nephew.
I believe he was 19. It is in the record, but I don't remember.
Okay.
Don't you have a problem, though? I mean, a lot of your argument seems to depend on saying that the arising out of may apply to employees of Uniscribe, but not third parties. But this was,
Yes.
Given the fact that the supervisor said it's fine for this nephew to be here working for us, why doesn't he need to be included as part of the employees of Uniscribe
Well,
for these purposes?
I think the issue, Justice Potzer, would turn on whether or not, even if he's an employee, whether that makes him an insured under the policy. It's an issue that was raised below, not raised on appeal, but he doesn't become an insured under the policy because he's clearly acting. Employees are only insured if they're acting within the scope of their conduct. This kid was, even if he was an employee, and I don't think the record is close to making him an employee, he was paid under the table. And he didn't sign the confidentiality agreement that employees were required to sign. But he doesn't become an employee because he's acting way outside the scope of his employment. The job was to scan documents, not to steal them and put them on the web.
Well, what if he had stolen the documents and Uniscribe, or whatever is on the documents, the valuable information, and Uniscribe decided to use it for its own purposes? Then
I have a problem.
Yeah.
Then I have a misappropriation of trades, a claim that arises out of the misappropriation by Uniscribe of trade secrets. I don't have a negligence claim against Uniscribe, and that's the critical difference.
All right. I lost track there for a second. You said the question of whether this person was an employee was resolved below and is not here on appeal?
I don't believe it's raised on appeal.
So was it resolved below?
I believe it was argued below by AIG, and that I don't know if there was an express finding. I think that Judge
But your view is whether or not he was an employee, there would be no coverage here.
No,
Because
I say
he
it's
wouldn't be an
irrelevant.
insured.
I say it's irrelevant because the argument below it was not whether it was that he had to be vicarious, that if he was an employee, he's then Uniscribe becomes vicariously liable
Right.
for his conduct, and it turns a negligence claim into a theft claim. And even if he's because he becomes an employee under the policy, that was the argument below. He doesn't become an insured. I mean, not an employee under the policy, insured under the policy. He does not become an insured under the policy because he's acting outside the scope of his employment.
Okay.
It's an issue they don't raise on appeal.
All right, I got it. I understand now.
You argue that, if I understand you correctly, that the arising out of clause is ambiguous because it's not clear whether it's referring to an employee of the insured or a third party. But why does it have to be either or? Why isn't it, in fact, perfectly clear? Why isn't the language perfectly clear? Because it includes both.
No, we believe that under existing precedent, it is ambiguous. It doesn't include both. Judge Hines relied on the Bagley decision, which is the argument that you're making, which is that the language is broad enough to include both misappropriation by Uniscribe and negligent of failure to prevent misappropriation by third parties. And Bagley involved a negligence claim against a motel for failing to prevent a rape by a patron. And there, this court found that the exclusion was broad enough to encompass negligent failure to prevent the rape. But there, the exclusion used the words arising out of, but went on to say, this exclusion shall specifically include, but is not limited to, sexual misconduct committed or alleged to have been committed by any insured. And this court focused directly on that language and says it's broad enough to pick up the misconduct, negligence against the insured for the misconduct of third parties. This case is governed by the Hermitage decision that this court decided, where it found ambiguity for precisely the reason that the exclusion doesn't say whether or not the misconduct is committed by an insured or a third party. And
That's the assault and battery case, is that?
that is the assault and battery case, Your Honor, but it's directly on point. Also directly on point is the HR knowledge case, which the appeals court decided after we filed our briefs here. There, restaurants hired an insured to process payroll. The insured subcontracted that work. There was an exclusion in the defendant's professional liability policy, the same kind of policy we have here, for claims arising out of any failure to pay or collect money. The restaurant sued because the subcontractor failed to pay taxes. The appeals court, which upheld Judge Gantz, found that the exclusion was ambiguous because it failed to distinguish between the claims where the insured failed to pay the taxes and claims where the insured was merely negligent in failing to supervise the contractor who had failed to pay the taxes. And there, the appeals court addressed the Bagley decision and found that Bagley was inapplicable because the exclusion in Bagley was far broader. The court pointed directly to the phrase, including but not limited to the insured.
I'm sorry, Mr. Schillinger, which case was that?
Yeah, could you give us that site again, please?
What's the name of the case?
Case.
The case I'm talking
appeals
about
court
is it's HR knowledge.
The 128, isn't it?
It's a 128 decision by the appeals court. We sent it to this court
I know,
in a
but-
letter.
We typically don't rely on 128s, as you know.
The reasoning is the same reasoning that this court, that Justice Graney engaged in the Hermitage case, where there is a clear distinction between exclusions that have language that make it clear that you are encompassing misconduct by third parties and not just misconduct by the insured. So HR knowledge merely reinforces Hermitage. But even if this court were to find this exclusion not to be ambiguous, there is a reasonable expectations argument to be made here. We had a reasonable expectations that this exclusion applied only if we were engaged in misappropriation. The court says, the court in the Gill case, which is we think on all fours with this, said that you have to look at the insured's particular business operations. Here, Uniscribe handles thousands of documents for law firms. It images them. It doesn't need to know, and probably doesn't know the content of those documents. So it doesn't know whether it's handling non-sensitive information, photographs, credit card information, or, in this case, intellectual property. It's not relevant to Uniscribe's job. So in just the way you have to look at the context, and if an intellectual property exclusion was attached to a software developer's policy.
But the other way to look at this is, yeah, Uniscribe is in the business of processing highly confidential documents for a variety of companies, law firms, that have this kind of intellectual property information in their documents, and the insurer wanted to be protected from the misuse of those documents, misuse of that intellectual property. Isn't that another way of looking at it? This is they're in the business of handling documents that contain all kinds of important intellectual property information. Isn't that their business?
No, their business is imaging whatever the law firms give them, and they don't know the content of what the hundreds of thousands of documents. In fact, the law firms may not know whether some of the documents may contain intellectual property.
Or confidential information. It could be just junk. The way document discovery is going these days, it could be junk.
It could be junk, and it could be confidential, but confidential doesn't make it
I understand, but
trade secrets.
Your point is you don't know.
Well,
one doesn't know.
Certainly the people that are, the Uniscribe people that are putting it on the copy machine do not know. And so you're creating a big gap in coverage, and I guess if you do it the right way...
Well, I'm sorry, but one of their
Yes.
subcontractors knew. He took it and put it up on the internet so that hackers could get it. I mean, knowing just means smart enough to figure it out. Your job puts you in contact with all this information. You're saying, well, your average employee at Uniscribe wouldn't know, but here's a perfect example of someone who obviously did know.
And this is a professional liability policy, and it's designed to protect Uniscribe from claims of negligence with respect to the mishandling of their documents. And if you did it the right way, I suspect that you could, in fact, create a narrow exception for trade secrets. But the reasonable expectations argument is much stronger here than it was in the Gill case, for the simple reason that when this intellectual property exclusion was added to our policy on renewal, we were told that it didn't change the policy, that it was not a cutback, not a restriction in coverage.
Had there been any discussion before about what it was not a cutback from? I mean, in terms of intellectual property?
Had there been any discussion before that?
Well, when you use this language, it was not a cutback from what you'd had before.
That's what they said, Your Honor.
Right. And so before that, well, you're just saying it didn't mention intellectual property at all.
Right. If you omit the exclusion.
Well, then what would it mean? What would it mean if it isn't a cutback?
It means that if you engage in the misappropriation of one of your client's trade secrets while you're doing their work, you aren't going to be covered. And that's why it's consistent with what they were saying, which is it doesn't really change the coverage. It's just a clarification, because one would assume that if Uniscribe actually stole trade secrets and used them for Uniscribe's own purposes, it wouldn't be covered. So it's wholly consistent with what they were actually telling us. And now they're advocating for something very different. And this is one of the arguments we make. There is a very large body of law which says that if you are going to change a policy on renewal, then you have to tell the insured and call the insured's attention to the change.
Don't you, the success of that position depends on finding this language ambiguous, doesn't it? Because otherwise...
Not at all, Your Honor.
Well, so you say that the judge was just wrong in that footnote about, when the merger clause.
Well, Yes, the merger clause shouldn't apply here for many reasons. First is that, in fact, neither of the parties below referred to the so-called merger clause. It really isn't a merger clause, but it referred to it. Neither considered it to be relevant, and neither party addressed it in any of the briefs below. So Judge Hahn shouldn't have used that to exclude the admissions. She actually excluded a letter from our broker, not these particular admissions that we're referring to, and so that's another reason they are actually admissions. If I could have 30 seconds to address our legal fees argument.
It's fine. Mr. Schlickinger, believe me, we will read them. So if you were responding to following up a question, but I think to start a whole new argument is a little beyond the scope. Thank you very much. Mr. Hughes, good morning.
Good morning, Your Honor. In deciding whether to affirm the thorough and thoughtful decision of the Superior Court judge,
Surprised you say that.
we were very pleased with the decision, Judge. There are certain facts that are undisputed in this record that we ask you to keep in mind. The first is that National Union was told by Uniscribe that Jones Day's claim for damages were caused by the theft of trade secrets, a felony under federal law. Indisputably here, if there had not been a theft of trade secrets, there would have been no claim by Jones Day against Uniscribe. So that's the first issue. The second important point.
Just run that past me again.
It's a
The point, Your
but-for
Honor,
argument.
is that but for the theft of these trade secrets, which was a felony under federal law, Jones Day would have had no claim against Uniscribe. Jones Day's damages were caused by the
Oh,
theft.
Sure. Okay.
The second point is that Uniscribe never sought a defense from National Union under the policy with respect to Jones Day's claim. Instead, all Uniscribe ever asked for was that National Union indemnify it with respect to the settlement that it intended to make with Jones Day. And that's a critically important fact.
Well, how do you get around the Hermitage case that says that the language arising out of is ambiguous? And if it's ambiguous, you read the policy favorably towards the insured, which is that the arising out of refers to theft by employees of Uniscribe.
Well, Your Honor, I think each of these cases have to be looked at in the facts of the case, the way Justice Hines did. And our point is the only black letter principle that applies to all of them is that the arising out of language connotes a theory of causation that is broader than proximate causation in tort. That's stated in Riccitelli, it's stated in the Bonina case, and that is a black letter principle that applies to all of these cases, and that's very important in this case. And the reason for that is, as I said, Uniscribe never sought a defense. Uniscribe, when faced with these facts...
Against Jones Day.
Correct. That's right.
They never asked AIG to defend.
They never did. They said, basically from the get-go, here are Jones Day's damages claims. Here's their letters. They're all saying that Jones Day was damaged by this theft of trade secrets. We want you to pay this settlement. So clearly, under the theory of...
The first letters came long before there was a settlement.
The first letters came before there was even a claim.
Right.
Well, there's the notice of claim, Your Honor, which was before there was a claim. But
Right.
then there were letters that they sent in from Jones Day shortly after that, saying where Jones Day was demanding
Yeah.
to be paid with respect to...
Well, that's just sending Jones Day's letters on. That's not saying we want you to pay. I mean,
Well-
isn't that saying this is a claim? We thought there'd be a claim, and guess what? There is.
Your Honor, it is clear from the record, and I would point you to the letter that's found on the record at A71.
Which date? Letter dated what?
It's dated November 5th, 2004, Your Honor. It's written by Mr. Schreckinger. And in it, he says, "In light of this final demand from Jones Day, on behalf of Uniscribe, I request that AIG reconsider its disclaimer, acknowledge coverage, and settle the claim with Jones Day."
Well, that is a defense. I mean, if you're seeking the settlement.
No, Your Honor, they never sought to dispute the validity of Jones Day's claim.
I mean, at least I think that defense means you need to represent us in connection with this case. We think this case needs to be settled because there's liability here, but that's defense.
Well, Your Honor, the cases, as you know, draw a distinction between the obligation of an insurer to defend under the policy and to indemnify.
I appreciate that fact.
And all Uniscribe ever sought was for National Union to fund the defense by paying the settlement that Uniscribe wanted to make with Jones Day. And the reason why that is important, Judge, is because Uniscribe expected that a natural, reasonable, and probable consequence of its negligence would be the theft of these trade secrets. Because if Uniscribe felt that the theft of these trade secrets was a supervening, intervening cause that would break the chain of proximate causation, it would have said, National Union, defend this claim. We're not liable to Jones Day. We didn't know about this kid that was in there doing this work. He stole trade secrets. We shouldn't be responsible for this claim. They never asked for that defense.
I think those are two different points, though.
No, they're not, Your Honor, because Rischitelli links them. Rischitelli says that causation under the arising out of language in an insurance policy exclusion is broader than proximate causation. And our point is, if Uniscribe felt that it was liable to Jones Day in tort for negligence, for this theft, for this crime, then clearly it had to understand that if it's liable under proximate causation in tort for negligence, and the arising out of standard is even broader than that, it had to understand that this theft of trade secrets was not covered by a policy that says we don't cover any claim arising out of any misappropriation of trade secrets.
Oh, I get your point.
Excuse me, Your Honor?
I get your point.
Okay.
I mean, it was the language that said they weren't offering they weren't asking for a defense. They were asking for a defense, but what you're saying is the nature of their capitulation, if you like, or their recognition of liability to Jones Day necessarily brings them into the exclusion.
Yes, Your Honor.
Okay.
Our point is that if they felt, as they clearly did,
Sure.
that they were responsible for this theft, then, and the standard for responsibility in tort for negligence when a criminal act occurs and causes the damage, which is unquestionably what happened here, if Uniscribe felt, as it did, that we're liable to Jones Day, notwithstanding this theft of trade secrets, then that chain of causation, Rischitelli tells us, is narrower than the chain of causation necessary to break arising out of language.
The problem with that argument, I think, is, and I'm not sure I buy Mr. Schreckinger's point, but Uniscribe could be liable because its supervisor said, okay, this guy can work here. That's one thing. But Uniscribe may take the position, as I guess it does, that he wasn't an employee and he certainly wasn't an insured, and we read the arising under language, as Mr. Schreckinger argued, to mean it only covers us, not some third party who's come in. We may be liable to him in a negligence count to a third party, but that's a different question about whether that insurance clause is triggered. I mean, I think that's what the argument is.
I think, Your Honor, with all due respect, they're very related, and it's not a relationship I'm drawing. It's a relationship that Rischitelli draws, and Rischitelli says that when you're looking at what the extent of causation is for an arising out of exclusion, it's not without limit. but certainly whatever its limit it is, it's beyond the limit of proximate causation.
Now, when you've been arguing based upon a letter that Uniscribe sent to National Union in Exhibit A, on page A71 of the record, but why don't we, instead of looking at that, aren't we supposed to look to the complaint that was filed and see what the nature?
There was no complaint filed, Judge. What you should look at, obviously, are the demand letters. There was the notice of incident. Then there were two demand letters, one at A59 and one at A69, two demand letters from Jones Day, where they're all saying our claim is based on the theft of trade secrets. This negligence issue develops much later, when Mr. Schreckinger gets involved. But prior to that time, when it was the demand letters coming in from Jones Day, all say our damages are based on the theft of trade secrets.
They don't use the word negligence.
No, not the initial ones, Judge. And then on the basis of that, National Union writes back and says, your insurance policy has an exclusion that says this policy does not apply to any claim arising out of any misappropriation of trade secrets. So you're taking these demand letters where they're saying pay us money caused by this theft of trade secrets, and you have an insurance policy exclusion that says, foursquare, we don't cover any claim arising out of a theft of any trade secret. It gets more esoteric when we move to the negligence area. But our point, Judge, is when we start looking at claim based on a theory of negligence that was articulated after the original denials by National Union, well, then let's look at the law on negligence. And the law in the Gidwani versus Wasserman says if the ultimate criminal act that causes the damage is a natural, reasonable, and probable consequence to the defendant, they're going to be liable for it. And the chain of causation is not going to be broken. And our point is, if Uniscribe accepted that and said, you know what, the kid stealing the trade secrets was a natural, reasonable, probable consequence to a theory of negligent supervision or negligent hiring, whatever it is, then clearly it was just as foreseeable when they read the arising out of languages in this insurance policy to say, we're not going to have coverage for that either, even though he wasn't our employee. Because if we're liable for his actions and it's not a supervening, intervening event, then our insurance policy is not going to cover it either because of this exclusion that says that.
Now, the Hermitage case would at least suggest that the arising out of language in the policy, the unadorned arising out of language in a policy such as this, should be read to mean arising out of misconduct by the employees of Uniscribe. What do you say about that?
Well, Your Honor, I'm saying that the difference here from that in Hermitage is that in the facts of this case, we have the insured recognizing its responsibilities for the criminal action of this person. And our point is that Rischitelli and the other cases that follow Rischitelli say that the scope of arising out of is broader than the scope of proximate causation. And here, if Uniscribe is accepting its responsibility for the criminal conduct of this person, then it has to also accept that event is within the scope of this arising out of exclusion.
Why?
Because it's for...
Let me ask you this. Uniscribe may make a perfectly reasonable decision that, you know, in a case brought by Jones Day, it's not going to win.
Right.
Right?
Well, Your Honor, it goes back to my other point. If it feels that theft by the nephew was not something that it should be responsible for, it has an insurance policy that would defend it against...
No.
It is responsible for, but it's a different question. I think the Chief Justice is saying whether the insurance policy covers it. That's a different question, whether it has liability to the third party. That is Jones Day.
Well, that's true.
That's what I was trying to ask you before.
But what I'm saying is that Rischitelli says that in terms of looking at the extent, or the extent of this arising out of language, whatever its limit is, and it's not without limit, it's not but for causation to the millennium. Whatever the extent is, it is broader than proximate causation for purposes of tort. And
You know, it's a little bit, I don't know how to do with it. You know what Venn diagrams are? You know, when you've got two circles and
Yes,
you've got
you
an
are.
overlapping. So let's take Mr. Schleckinger's point, just arguendo. Your policy under the intellectual property exclusion applies only to employees of Uniscribe. That's all it applies to. Okay, let's just take that as a given. Let's say you agreed. You don't.
All right.
You agreed. And an unauthorized, but nevertheless, you know, the uncle had no authority to hire this kid in off the street and didn't supervise him and so on and so forth, and then nobody up the Uniscribe line knew about it, but the kid is there and, you know, steals some trade secrets from Jones Day. And Jones Day comes along and says, you know, whatever it says, you know, excuse me, we gave it to Uniscribe and we're not responsible. You know, Uniscribe can go after the kid and the uncle and everybody else, but from Jones Day's point of view, it had given the documents, you know, and Uniscribe messed up. Fine. So it says, does a careful analysis and says we're liable to Jones Day, and by the way, we may also cross-sue the uncle and the nephew, you know, who maybe they are multimillionaires or something, and they get it back again. But through all of that, it's maintaining the position that this exclusion applies only to its employees, so that you've got a much larger area of potential tort liability, but it's not, it doesn't encompass anything beyond the employees.
well, Your Honor, then you have to go back to the insuring clause, because the insuring clause says we only cover you if there's a legal obligation to pay.
Right.
So
Right.
if some interloper breaks in and steals DirecTV's trade secrets from the room that Uniscribe is using, that wouldn't be a covered claim anyway. If there isn't at least an arguable basis for the insured to be liable, that's not a covered claim. And again, if Uniscribe had said, this is a ridiculous claim, we can't be liable for this, you need to defend us, that would have been a different situation. That's not our facts.
No, I understand that. But vis-a-vis, you know, Uniscribe tries to, but vis-a-vis Jones Day, Jones Day doesn't care whether or not Uniscribe is or isn't legally responsible, right?
Well, Uniscribe should care before they pay him $1.2 million. Uniscribe should only be paying if it believes that there's some basis for its liability. And you don't get to the exclusion, Judge, unless you first find that the claim triggers a legal obligation on the part of the insured. That's a condition in the insuring agreement. So I think that's the best way I can answer the Court's question.
Thank you very much.
Thank you, Your Honor.
Mr. Hughes.